Hello, everyone. Thank you so much for joining us today. My name is Jay Huang, and I am a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the EB-5 investor green card and its rules and requirements. So just a few housekeeping items before we get started. Some of you may know that the firm Scott Legal was founded on an E2 visa several years ago, and our founder actually is in the United States on an E2 visa and has been on several different visas, including F1, TN, B1, and H1B visas. As such, we know what you're going through. This firm is a full service immigration law firm, and we do offer immigration services in a number of different areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB5 investor green cards, extraordinary ability visas, and more. Now, we'll be continuing doing this webinar series, and we're doing at least 2 webinars a week on different topics regarding immigration law. And at the end of this webinar, we will be sending out a couple of useful tools for all participants. So first, we will send you a copy of the PowerPoint presentation that we will go through today. We will also send you a link where you can download guides that go through the visa options in more detail. We will also send you a link that you can follow where you can sign up for additional webinars that are coming up in the future on different topics. And this webinar will also be recorded and be available on YouTube. We will also send the link for that. And we do encourage you to subscribe and hit the notification button to our YouTube channel, as we do regularly upload a variety of immigration law related videos that can be useful to you. And finally, we will also send you a link that you can follow to set up a consultation with one of our experienced lawyers, should you wish to discuss your case in further detail. So today we are very lucky to have Ian Scott, founder and managing partner of Scott Legal PC, to present today. He graduated from Harvard Law School and have extensive experience in processing a wide variety of EB-5 petitions. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us get started with the webinar.
Great, thank you very much, Jay. So, as Jay mentioned, we're going to talk about the EB-5 visa. And really, when we start the conversation related to EB-5, we first think of it in terms of breaking it out into really two different sections. And one is regional centers, and the other is a direct investment. And when we think of a regional center, just an example of a regional center might be a situation where a large company, like let's say the Hilton hotel chain, decides that they want to build a mega resort somewhere in the United States. And they say that they want to utilize the EB-5 program to raise capital, and they collect a bunch of money from a number of different people. And in exchange, those people might get green cards. And if we contrast that to a direct investment, this might be someone who wants to start a restaurant and they want to invest a certain amount of money into their own business, and then they want to utilize that particular business investment to get a green card. So when we think about a regional center and the different profiles of the people, when we think about regional center and direct investment, and we think about the different profiles of the people who are really interested in these two types of investments, the regional center profile, the profile of the individual, usually the person wants a fairly passive investment. They don't really want to do very much. They want to give somebody else the money, have them take care of it, because as we'll talk about a little bit later, that there are things that have to be done. You have to create jobs in order to get the green card. So they prefer not to do that. They're okay with paying high administration fees. Usually when you invest in a regional center, the administration fees can be $30,000 to $50,000, and sometimes even more. And they are actually also fine with very low returns. So they're investing quite a bit of money. You'll see the amounts in a little bit. And they're fine with what actually works out to negative return, because when you factor in the administrative fees, then they're actually making a negative return, and they are fine with that. The regional center is one thing to kind of keep in mind, is that they are, it is an investment. And even though regional centers have to get some type of approval from USCIS to operate, that does not mean by any stretch of the imagination that the government is approving or vetting the projects. This is an investment, just like any other investment in the stock market, et cetera, where you could lose everything and also lose your money and maybe not get the green card. although that is rare. The other thing with the regional center is that when you're investing in a regional center, you can include, because we're going to talk about the requirement to create jobs, you can include things like indirect jobs. And what we're talking about there is that when we are looking at job creation, we're looking at direct jobs. So example, the hotel example, that might be people who work at the front desk, that might be people who clean rooms, etc. But then also you can get an economist to write a report which basically says that as a result of the hotel being there, there are surrounding businesses like dry cleaning, caterers, etc., where there are indirect jobs that are created, and those can be used to increase the number to the requisite number of jobs that are required. And we're going to talk a little bit more about targeted employment areas as we go through this. And the other big thing with regional centers, and this was certainly a change, because in the past, both direct investment and regional centers could support multiple investors, but now that is something that is limited to regional centers. Because when we move to direct investment, the example that I just gave of the person who wants to open their own restaurant, let's say this happened to us, we had a case like this a while ago where we had a client where it was two brothers and they both opened a restaurant, and they both were given the petition was approved, and they were both able to get the green card. But the rules changed in 2022, and now that situation, it could not exist because it can only be one green card per entity under the direct investment program. But the profile of an individual who's investing in the direct investment program, they really want control over the process. They want control over the return. They want control over who they're hiring. They're not really interested in a passive investment. They're really interested in kind of running the show and making sure that considering or taking into account that could mean that there are additional risks, but also it could mean that there are significant rewards associated with that. And as we said, when we're talking about indirect jobs, only direct jobs can count here, so we can't use indirect jobs at all. Another kind of important thing with respect to the direct program is that, and this created significant issues in the 2021 when the program wasn't reauthorized. The regional center program wasn't reauthorized because that actually does require government reauthorization every once in a while, whereas the direct investment program is kind of codified in statute. And even when the regional center program wasn't operating for almost a year and a half, or maybe even a little longer, the direct investment program was still able to function without any issue. Perfect. So the EB-5 program really has, in this, regardless of whether we're talking about direct investment or whether we're talking about the regional center program, it really does have two main areas that we're always going to look at. And the first one is investment. So, the individual or individuals are going to have to invest money into some business. And the second one is going to be job creation. And we're going to talk about both of those. And then we're also going to talk about exactly what has to be filed when you are doing an EB-5 filing. So investment. So item number one. So the crux of this program is that an individual has to invest either $800,000 or $1,050,000 in a new commercial enterprise. And that's not a new, it says new commercial enterprise in terms of the way that the statute defines this, but new commercial enterprise is really an enterprise that was developed after 1990. So this could be someone who's starting a business and invests money into the business. This could be there could be an existing business that was created after 1990 where someone invests into that business. All of those could qualify for EB-5. The one thing that doesn't qualify, and this is very different from E2 visas, is the situation where there's an existing business and someone buys the business and gives the money to the seller. Because the example that I gave just now, I was giving an example that was slightly different, where there is an existing business and the individual invests money into the business and say, puts it into the business bank account, maybe gets some shares, and then the money is spent in that business. That's very different from the situation where you're buying a business. Let's say there's a restaurant for sale for $800,000 and you give the seller $800,000. The seller takes $800,000 and then, goes and buys a condo in Florida or something. And that's different because the reason that doesn't work is because the money that was invested doesn't support job creation. All that, the actual seller got all the money. The difference between the 800,000 and the 1,050,000 is going to depend on whether or not the business or where the business is located. And if the business is located in a targeted employment area, then it's going to be 800,000 and everything else is going to be 1,050,000. The targeted employment area, there are two ways that you can meet the TEA designation. One is that you are in an area where the unemployment rate is 1.5 times the national average. That's one way. And the other way is that the business is in an area that is a rural area, and that's going to be defined based on local populations. So if it's a TEA, that's going to be 800,000, if not more. And we're going to talk about why this is important in particular for individuals that were born in China and India, why actually meeting the $800,000 threshold is very, very important, because if not, there are going to be very, very long waits for the green card, but we're going to come to that in a second. So a lot of our clients that are, that we've obtained an E2 visa for decide that they're going to expand their business and they're going to invest in the EB-5 program. And they ask these questions, which investments can we include? A lot of the investments are similar, but a few things to keep in mind is that the EB-5 program is extremely particular with respect to the investment and what can be included. So for example, you cannot include things like the administration fee that you pay to a regional center. So you'd have to invest $800,000 in the regional center. And then if there was $30 or $40 or $50,000 administration fee, that couldn't be part of the 800,000. You couldn't include legal fees in the investment amount. Also, you have to be very, very careful with respect to money that's paid back to the owners or investors. So that's another, or their family members. So that's another thing that is going to be very, very important. And we're going to go through an example at the end of the EB-5 presentation that illustrates some of these points. But the one very important thing to take away is that the EB-5 program is extremely exacting, right? So they're not, this isn't kind of a general exercise where we can kind of narrow in on different aspects. They're extremely, extremely exacting with respect to the documents and the requirements, and you could invest $799,000 and your petition could be denied just based on the $1. Another good example I like to quote regarding how exacting this particular area is that in the past there was when people were investing in regional centers, and sometimes it was children, so parents would be giving money to their children to invest in a regional center. So they would give them, let's say, 800,000. I think at that time it was 500,000 when this was happening, because it rarely happens now because we give so many warnings about it. But the parents would, because they didn't want to put the money into the children's bank accounts, because who knows what the child would do with the money before it got to the regional center, they sent the money directly to the regional center, but still gave the child a gift letter, et cetera. But USCIS denied a number of those petitions, saying that the child did not have possession and control of the funds, so they didn't invest anything, even though the money came from their parents, even though there was a gift letter, but the money didn't actually hit the bank account of the personal bank account of the child before it was invested in the regional center. So again, they can be extremely, extremely exacting with respect to do different things, and sometimes even as time passes, rules can even change. So another kind of key thing with respect to investment is the whole idea. So let's just go through an example of an individual who starts a company, and then let's say they in year one, they made $3 million profit, right? So they made $3 million profit. So the profit ends up in retained earnings. And then they said, hey, I made $3 million profit. And then they started the next year and they started spending the money. And then at the end of the year, they say, hey, I spent over $800,000, or I spent $1,050,000 out of my retained earnings. And, I want to apply for an EB-5 and I've created jobs and I want to submit an application. So retained earnings doesn't count as investment. The example that I gave about the parents sending money to the kids, it's similar. The money has to come from outside of the company. So in this particular instance, let's say the individual wanted to pay themselves. through distributions and pay taxes on the money. The money flowed outside of the company and then was reinvested. Then that could work. That could work for counting the money towards investment. But retained earnings, the accumulation of retained earnings, unfortunately, is not enough. The other kind of big important thing is that the same reason that the individual buying a company doesn't work for EB-5, we have to consider that the investment has to relate to the job creation. So let's say, for example, that a company started and the company started generating revenue right away. And let's say that they had 10 full-time workers that were that they hired in within a 2-month period. And then let's say a month later, after the 10 full-time workers were hired, they invested 800,000 or $1,050,000. Then what's the job creation that's required? Well, in that case, 10 new employees are required, because the 10 employees that were hired before had nothing to do with the investment amount or the amount of money that was invested. So something to consider as you're going through. Timing really does matter with respect to when you received the money. The other very, very important thing, and this is, this can be extremely frustrating for individuals, is the source of funds analysis. So we do E2s regularly as well, and the E2 source of funds analysis is something that is, it can be extensive depending on where you're filing, if you're filing at USCIS or if you're filing at certain consulates. But for EB-5, unfortunately, it's always a challenge, always extremely difficult, and there's no page limit with respect to it. And they are very exacting with respect to tracing the flow of funds and then also showing the money, showing where the money actually came from. Because on the face of it, the requirement seems straightforward, that the money came from a legitimate source, right? That it didn't come from things like money laundering or illegal activities, et cetera. But that it really is taken to an extreme degree with respect to the amount of documentation that's required, and even with extensive documentation, sometimes thousands of pages of petition in a petition will still get RFEs asking, requests for evidence, asking for more explanation or more documentation. And then the final thing on this slide is the investment does have to be an equity investment. So it can be a limited partnership unit, it can be a membership unit, it can be a share, but it can't be like a loan, right? You can't, then maybe the final thing is that you cannot, there can be kind of no guarantee of return. So I've said earlier that this is an investment just like any other investment. So it really is a situation where everything has to be, there has to be a risk of loss. That sometimes people on the direct side are certainly more comfortable because it's their own business. But unfortunately, you can't, for example, in a regional center, put in your contract, well, you guarantee to return my money by X date. That's unfortunately would kill an EB-5 petition. So the next significant aspect of EB-5 petition have to do with jobs, right? So you're also required to create 10 full-time jobs, and they're not just any jobs, right? So we talked a little bit about direct and indirect already, but the jobs actually have to be for US citizens or green card holders. So it is very, very important for people that are engaging in the EB-5 program to make sure that they're using E-Verify or some other mechanism to make sure that the people that they're hiring are actually US citizens or green card holders. Because anyone else, even if they have legal authorization to work, they don't count in terms of the 10 full-time employees. And of course, the obvious people who don't count, like yourself and your family and things like that, those people don't count. And we talked a little bit about the link between the investment and job creation. If you're doing a direct investment, you're going to have a business plan. There's a famous case, it's called Matter of Ho. It was a case where the person invested $500,000. The investment amount was $500,000 at that time. They invested $500,000. They put it in a bank account. They made a 3-page business plan and then submitted a petition to USCIS, and it was denied, and they appealed. And the appeals board said, well, no, the business plan was not sufficient. It was not credible. It was 3 pages. Matter of Ho has lots of things in it that are interesting, but the business plan wasn't interesting because they also didn't like the $500,000 sitting in a bank without any spend. They didn't like that either. So, but Matterpo was a fascinating case for kind of pulling out some details with respect to direct investment EB-5 that are very, very helpful. And we talked about the E-Verify and documenting, what we'll usually submit with sometimes at the first stage, but certainly at the last stage, which we're going to talk about the filing, we'll submit I-9 forms, we'll submit passport information, we'll submit green card information, et cetera. But you have to be careful because sometimes an employee will not be honest with respect to their immigration status, and they'll, hand you fake documents. And we've had that happen before where we submitted an EB-5 petition, and luckily it was at the I-526 stage, and the government came back and said, well, of the 10 people you've listed here, 2 of them, they're not, legitimate. We, of course, didn't know that, and even the employer didn't know that. But they didn't tell us even which ones were not legitimate. But we just argued that at this stage, we don't have to create the jobs. We still have lots of time to create the jobs, and they accepted that argument. But when we filed the I-829 for this client, which is the petition that shows that the jobs actually have been created, we were extremely particular with respect to making sure that everyone that we submitted had a valid green card or valid citizenship, passport, et cetera. So in terms of what's filed, so with an EB-5 filing, there are going to be 3 major steps. So the first step is going to be filing an I-526 or I-526E. If it's a regional center, it's going to be an E. If it's not, it's I-526. And what this petition really is doing is showing that you have met the criteria that we just described, right? That you are going to be able to create 10 full-time jobs, that you have made the investment, that there are no restrictions or guarantees with respect to the investment, that the source of funds is fine. The I-526 is, we'll call it kind of the hard part, right? So that's the part that is a bit more difficult. The second part of the process is the standard process for any green card, right? So any green card that someone's going to get, they're either going to be filing an I-485 petition or doing consular processing. And if they're in the United States, they have the option of doing both. But if they're outside the United States, then they can only do consular processing. The one great thing in 2022 that was changed is that the I-485 can be filed concurrently with the I-526. Before 2022, that was not the case. And given that I-526 petitions are taking years to be approved, 4 to 5 years to be approved, this is a significant benefit to applicants because they can be in the United States, they can file the I-526 petition, and they can file an I-485 petition, which gives them ability to work, gives them work authorization, gives them authorization. So they really have a lot of the benefits of the green cards for the 4 or 5 years that they're waiting for the petition to be approved, which makes sense because that's a crazy amount of time to be waiting for any petition to be approved. So the people should get some benefit. And then the final part of the process is the I-829, which is 2 years after you have the green card, then coming back to the government and saying, hey, I actually have created those 10 full-time jobs that I said that I was going to create. Now, one kind of thing to keep in mind with respect to the process, when you're looking at 5 years and maybe some time for the I-485 consular processing, and then the I-829 that could take 4 or 5 years to be approved. It is a long process. That clients are in this process for a long time. But as I said, with the I-485 filing, you do get some benefit. Now, I think we talk about it. We're going to talk about it later, but I may as well just talk about it here a little bit as well. So the I-485 can be filed concurrently with the I-526 if the visa category is current. And for most countries, it is current. The only countries that it's not current for is India and China under the regular category. But there is a carve out, and I don't want to get into this too much here, but there is a carve out where the government, another change in 2022, where the government set aside a certain number of petitions for areas that were high unemployment, so the 1.5 times the national average, areas that were rural, and areas where the project was an infrastructure project. And the carve out in essence means that the people who apply after 2022, that all of those categories are current for every single country. But in order for them to be current, that's why I said the 800,000. is sometimes a big draw, because if someone was investing in a direct or regional center and they were not in a high unemployment or rural area, then, and they were from India or China, then their category is not current. Right, so that would be that would mean that they would have some, you know, a long delay with respect to getting the green card, and if they were in the United States, they would not actually even be able to file the I-485. We have clients that filed before, let's say filed in 2020 or 2019, that are still not current, from India or China, that are still not current, whereas we have clients who filed after 2022 who already have their green cards. So it's just, I mean, it's unfair. It seems a bit unfair, but unfortunately, there's nothing that you know, nothing we can do about it. It's just the way that the rules kind of ended up playing out. So key changes to the program, and again, these were in 2022, and some of these I went over. The investment amount used to be 500,000 for TEA, and it went up to 800,000. For the other one, though, it only went up 50,000. It used to be $1 million, and it went up to $1,050,000. There were some interim numbers that there were some lawsuits and things like that. So these are the kind of final. This is what the current thing is. The program was reauthorized until September 30th, 2027, and anyone who files before September 30th, 2026, their petition actually will be adjudicated. And this was a huge change because that was a big problem, because when they didn't reauthorize the program last time, USCIS just shut down, said we're not doing any petitions. And that, you know, enormous amount of uncertainty, especially, you know, you've invested a ton of money, and you know, USCIS just saying, well, I don't know, I'm not sure what I can do, and but this was a good change. They did change as well what constitutes a TEA, making it a bit harder. But TEA is pretty objective, especially if you're doing it with respect to the high unemployment rate, because you can go to a census tract and look to see exactly what the unemployment rate is, and then compare it to the national average. So, and there are TEA calculators that you can use to do this. And then the set-asides that I talked about before are listed there, so for rural areas, high unemployment, and infrastructure projects. So the other change we talked about already, I-485 can be filed concurrently with the I-526, as long as the category is current, which is great. Work authorization, we're seeing work authorization about 3 months right now. Travel authorization is longer; it's about 9 months to a year. So if you do file an I-485, you do have to commit to be in the United States for 9 months to a year before that's approved. You can't leave until that's approved, or your I-485 will be considered abandoned. So that's something. If you have some emergency, like death of a family member, or some medical emergency for a family member, you can sometimes get a 30-day ability to leave for 30 days. And then there were some other changes that we talked about, where, because before the amount of money could include administrative fees and things like that, but that's not possible. Not possible. So the other thing that we had here is, or just want to touch base on, is loans and gifts. So the government was actually a little, when they were going over the 2022 changes, the government was kind of going back and forth with respect to what they should do with loans and what they should do with gifts, right? So with gifts, what they wanted to do is they wanted to say that gifts are only possible if the individual is, you know, an immediate family member, right? Because I guess they were concerned about people saying, I'm giving gift, but then they ended up, you know, moving away from that, and nothing changed. The thing is, with loans were very interesting, and really loans, I think that the exercise of litigation, not just accepting what USCIS says, sometimes is really effective, because what happened was, in the past, the USCIS would accept what unsecured loans, right? Loan is unsecured. They'd say, fine, no problem. But then just all of a sudden, they just started denying those petitions, saying that the money wasn't at risk, with no real basis for it, right? But they denied many petitions. So then there was a group who sued and said that the regulations don't say this, and they won. So they actually had to go back and approve those petitions. And now, of course, unsecured loans are not a problem at all, because they lost that lawsuit, and I don't think they actually ever even appealed it. So that, you know, so that's what we that's where we're at right now, which is great. And then there's another kind of change in 2022, where it kind of gives you the ability to change the program if the regional center fails or closes. So that's something that what didn't exist before, because you could be in a situation where there might be like a regional center, and the regional center was hit by a tornado and destroyed, like the project was destroyed, and that, there wouldn't be a basis for anything other than you not getting the green card and not getting your money back. But there's now a basis to kind of move to other projects. So it's a little bit more complicated than what I'm describing, but. So a few things to consider. So the matter of hoe case that I talked about, where you can't just kind of invest, $500,000, you can't just put money in a bank account and just do nothing and just apply for an EB-5. You do have to have, commitments. You have to have spent money and you have to have commitments in order to apply for an EB-5, because if not, they'll just think that, well, you have money sitting in a bank account, and if the money's sitting in a bank account, then you could just take it out, and that's not something that qualifies. And we talked about loans and gifts already. Considerations for purchasing a business, we talked about that as well. And as I said, it can work, but just the situation doesn't work if you're purchasing the business and you're purchasing the business and you are giving the money directly to the seller, right? So you can still accomplish your goal, like a business exists, and you put money into the business, you take some shares. Just give me 1 second. Okay. You put money into so you could actually accomplish your goal, but it just has to be done in a manner that meets the actual regulations. In terms of how much you own, it's, this is very different from E2. When you have an E2 visa, you have to own, at least if you're the investor, you have to own at least 50% of the company. And here you don't, it doesn't matter. You can own a fraction of a percentage. You can, but it does have to be some type of equity ownership, but it can be a fraction of a percentage. That actually satisfies the requirement. And we talked about guarantee of return, and that you can't have that. And you do have to be very careful, even in terms of one of the things that we're always focusing on when we're looking at the corporate documents for direct investment EB-5 petitions is what the corporate documents say, right? Because if they say, and this has happened before, where they say something like, person can take the money out, and then the wording makes it such that the actual funds are not at risk because the person can actually take the money out. So we have to be very careful of that. Because that wording can kill a petition. We had a RFE for a petition where the examiner just missed where we had amended it. We saw it, and we actually added an amendment to the operating agreement where we amended that particular provision, but the examiner missed it but pointed out that this provision says this is a big problem. But we were able to show them the amendment, and we got a couple of legal opinions to indicate that the amendment accurately amended that part of it. But that's something that could be a problem. The E2 to EB-5, it's a great way to move to a green card. It's it definitely works, and I think that a lot of our E2 clients have entrepreneurial spirit and like the fact that they can keep their business and manage it and invest maybe a little bit more money. And keep in mind as well that the investment doesn't have to be all made at the same time. We did an EB-5 direct investment for a client where they made, I think, 5 different investments over the years. I think a few things you have to keep in mind. And if you want it to be a TEA, every time an investment is made, the business has to have been in a TEA. So that's a few things you do have to kind of monitor the process very closely. And especially if you're doing E2 and moving to EB-5, and you think that you have even the slightest thought that you possibly will do that, you do want to make sure that you're planning from day one, because if you have an E2 and you do the source of funds analysis for E2, it's very different. Even though on paper the analysis looks the same, it's going to be very different for EB-5. So you want to actually document and make sure that you have everything put together. The other big difference between E2 and EB-5 source of funds, if you're doing a direct investment EB-5 and you have a company, the EB-5 company, and the EB-5 company had any other investment made in it by anyone, even someone who is not an EB-5 investor, you have to do the source of funds analysis on all of it. So that there's just a very specific regulation that USCIS brought to my attention once that and you know, sometimes it could be sometimes that it's just that no one else is invested, right? But when they brought it to our attention, they were like, well, it seems like someone else is invested. We want more information on what they invested, but we were just able to show them that no one else had actually invested. But unfortunately, that's the thing, is you really have to, like if you had 10 other people that invested in the company, then your source of funds exercise has just exploded, right? Because you do have to provide the same source of funds analysis that you would have provided just on the $800,000, and it's a very explicit regulation that addresses that. So it's not anything that you can argue that you don't have to provide. It's not a nice to have. It's actually a very explicit regulation that even goes as far as to say that even if the person is not applying for a green card. So it's very, very clear. Like there's just no way of arguing around it. So it's something we're very conscious of when we're putting together EB-5 direct petition. So perfect. So I think the last one is a case study. Yes, perfect. Okay, so let's go through this case study and talk about a few things here. So this is a person, Helen. She got an E2 visa in 2015, and she purchased the shares of the business for $300,000. So she gave the seller money, 300 grand. And the business had 5 full-time employees when she purchased the shares, and she paid lawyers, 40 grand. In 2019, she invested another $500,000, and then she got that from a gift. And the person who gave the gift, got that from money from sale of a property that they inherited 15 years ago. And instead of giving the money to Helen, they deposited the money directly into Helen's business bank account, right? That was, that's something that they did. When the money was invested, by that time, because it's a little later, 2019, she had 10 full-time employees. So she hired 5 more. And then at the end of 2019, she paid herself a bonus of $100,000 after the company made $1 million, right? So then in January, she applied for EB-5 green card, showing a total that she'd invested 1.8 million, 300,000 plus 500,000 plus 1 million. The 1 million is in retained earnings that she had made over the company over the years. And she also included information. She's created 10 full-time jobs, so she's done. She said, I'm done, because she didn't really want to hire anybody else. She's not committed to really hiring anyone else. And the unemployment rate at the time is 7%. So let's talk about Helen and her situation. So first of all, Helen applied for an E2 visa. We would have done a source of funds analysis of where she got the $300,000 from. But that source of funds analysis is pretty useless because this investment can't count anyway. So the $300,000 was paid to the seller, and that doesn't have anything to do with job creation. And $40,000 in fees can't count either, because legal fees can't be counted. And also the 5 full-time employees that worked at the company don't count for job creation either. So the company can still be used, but if it's used, you need to invest more money, right? So at the end of 2019, it looks like she's done that. She's invested another 500,000, and then she got that as a gift. Gifts are no problem. But look at where she got the money from the person who inherited property 15 years ago. And the reason we, included this example is USCIS does not care whether it was 15 years ago, 25 years ago, that the person has died. They don't care. If you can't provide the documents, they'll deny your petition, right? So the person that gave the gift has to prove where they got the money. And it's not enough to say, well, I inherited it from my relative who passed away, because the USCIS is going to want to see where that relative got the money from. And even though it was 15 years ago, 20, 25 years ago. We've had cases longer where USCIS has been going on and on about getting more documents. And then the other big issue here is that Helen gave the money, put the money directly in the business bank account. So the government would also argue that even the 500,000 didn't count, even if they were able to prove the source of funds, the 500,000 didn't count because the 500,000 was not given to Helen. So she didn't have possession and control of the funds. And then, but let's say that the 500,000 did count, then the 500,000 would go towards showing, and we could prove the source of funds. It would go towards showing that she hired 5 full-time employees, but again, the original 5 wouldn't count. Now, in 2019, she paid herself a bonus of $100,000. Now, this is very, very important when you're looking at EB-5 direct and paying yourself money out of like in this example, it's not clear that it's a problem, but the thing you have to keep in mind is that it could be a problem, right? So let's make this example clearer that it is a problem. Let's say that the $500,000 counted towards investment, and then the business that year didn't make much money, and then she also paid herself a $100,000 bonus. You can't invest money and then pay yourself the money, right? That's you have the calculation is very, very important, and you have to kind of make sure that USCIS can't raise these types of issues. So when she says that she's, invested $1.8 million, the $1 million doesn't count at all. The retained earnings doesn't count at all. The 300,000 doesn't count at all. And even the 500,000. So she's invested nothing, which also means that it's 0 jobs that she has at this particular point in time. The one thing is she isn't a TEA because the unemployment rate is 7% where she is. And current unemployment rate is around 4%. So, she's definitely in a place where the unemployment rate is 1.5 times the national average. So she just has to invest another $800,000 and create 10 full-time jobs. So. Perfect. So, and the final things to be aware of is that the timing, like the EB-5 petitions take a long time to get approved. The I-526 petition takes 5 years, sometimes 4 to 5 years to be approved. Sometimes if the regional center is in a rural area, that can be approved faster. The country-specific quotas, so we talked about India and China, but other countries have been delayed as well. So that does happen sometimes, but it hasn't been a kind of a all country delay like we've seen in some of the other categories. I think that you always have to, because of the long wait times, you always have to be cognizant that your visa may expire and making sure that you're maintaining underlying status. The fact that you can file an I-485 as long as the category is current, that could help. But if not, you want to make sure that you're maintaining underlying status. And then if you are leaving the country and you have, for example, a non-immigrant visa, you want to make sure that you're considering that and making sure that you, when you enter, that you're considering kind of the dual intent considerations. Because even if you are filing an I-485, you do have to be cognizant of the fact that you can't just leave the U.S. and then enter with the intent to adjust status and then just get back to the U.S. and do it. You can't have that intent when you enter the United States. You can get to the U.S. and your plans change and you decide to adjust status, but you can't have that intent when you enter the United States. And USCIS can challenge you on it, like they can, and I think you can see, you should expect to see that where they say you entered, 2 weeks later you filed a adjustment of status, and we now you rebut the presumption that you didn't have the intent, right? So they won't say that they have to do anything. They say you come up and prove to us that wasn't your intent, and that can be problematic for an applicant, right? Sometimes we do have people that have parallel green card strategies. We're working on a petition right now where the person's doing NIW and EB-5, and we've seen that in the past as well before. But planning is definitely key with respect to EB-5.
All right. Thank you, Ian. That was a very informative presentation. I'm sure it was helpful for all of our participants. Let's see if any questions have come in. I don't think so.
I think there's one in the Q&A.
Oh,
maybe
okay.
two in the Q&A, yeah.
Oh, yes. Let me pull that up. Yes. Okay. All right. So first question all right. If the person is outside of the United States and they are originally from Iran, should they wait until the 526 is approved, which takes a few years, and during this time the money is invested and they are remotely working with their business partner? If they come on a business visa to the United States and apply for a visa, would they get the EAD and travel document on the basis of a pending 485 and can possibly travel while the 526 is pending? Can they invest in a business that belongs to their brother?
Yeah, so the easy question is you can invest in a business that belongs to your brother. That's a easy question. I think that if you enter the United States on a tourist visa or a business visa and you don't plan on adjusting status when you enter the United States and then you later decide to adjust status because you're in the United States and your situation has changed, then it is possible to adjust status. But this question maybe came before that description that I had with respect to the possible issues with respect to adjusting status when you have the intent to adjust status. So that's something to consider. I'd say the only other thing I would say is that depending on, I think you said you live in Iran, so I would say that the one other thing you do have to kind of pay particular attention to if the money is coming from Iran is there's serious OFAC considerations with respect to that, and it's just making sure that those are all covered because the government will raise those. So it's yeah.
And for the legal fees question, we will definitely, yeah, you can set up a consultation and we will, be happy to provide you with more information with the engagement letter. You can review all the fee information there. We don't share the fee information in the webinar itself, but definitely get in touch with us if you're willing and, you would like to speak to one of our attorneys to process your case. All right. So I think that was all of the questions. Thank you so much, Ian, for sharing your very valuable expertise. And thank you, everyone, for your participation. And we will close here.
Perfect. Thank you very much. Okay, take care. Bye.
Thank you.